In this episode of The Real Crimes of Kurri Kurri, we discover that if you're charged with a traffic offence, you may not be entitled to see the police brief of evidence prior to the hearing day. The brief of evidence is all the items the prosecution is going to use to attempt to prove the elements of the offence beyond reasonable doubt at the hearing. So the defendant might not get to view the evidence, such as dash cam from the police car, until the hearing day. By the way, other cases such as violent type cases, the court will order a brief to be served on the defendant, so they get to see the evidence beforehand. However, some traffic cases are exempt and the court is not required to order it to be served. The exemption can be found under Criminal Procedure Regulation 2017. It's Regulation 24 and it's called Offences for which briefs of evidence not required. The law lists all the exemptions. This includes summary offences such as offensive conduct, some drug possession, some charges relating to prescribed restricted substances, some offences where a penalty notice may be issued. Now that's the law not requiring the court to order the brief to be served. But some people may argue that doesn't stop a person from just approaching the police and asking for the brief of evidence. Really, that becomes a matter between the defendant and the police. And I think legal advice would assist here. By the way, why would someone want to see the evidence before the hearing? There can be many reasons. To develop a defence strategy beforehand, to prepare relevant defence material including witnesses, perhaps to prepare an argument as to why it shouldn't be used in the case. You might see footage of yourself and decide to change a plea. Thanks to Kurri Kurri Local Court, we are reminded of the procedure. So beware, depending on what you are charged with may mean you don't get to see the evidence until the hearing.